Organize it in a way that nobody is too close to each other. It's fine. Good evening, everyone. In fact, I heartily welcome all of you because post-pandemic, this is the first physical event that the Bar Association is holding in collaboration with TISS. And we are indeed honored to have my Lord Justice Goel with us. And we are going to discuss a very pertinent topic, which is a topic for future. But we must begin the groundwork today. And the topic is rivers in Indian law, opportunities and challenges for legal rights for rivers in India. I would now request Professor Aseem Prakash, Deputy Director, Tata Institute of Social Sciences, to kindly say a few words.
Good evening. Honorable Mr. Justice Adarsh Kumar Goel ji, Shri Prashant Kumar ji, the President of Bar Association of India, my colleagues from my Tata Institute of Social Sciences, and colleagues from across the world, Colombia, New Zealand, Norway. A very hearty welcome to all of you to this two-day workshop on rivers in Indian law, opportunities and challenges for legal rights for rivers in India. It is an occasion which brings together academics, legal peers from diverse cultural contexts to study rivers. This is the context, sir, in which you have kindly agreed to to inaugurate this workshop. We are very, very fortunate that you could find time and be present here. When I was reading the concept note, I was very fascinated with the whole idea, the way the scholars are trying to interpret culture, law and society, and trying to understand how can a river have an entitlement which is legal in nature. When I was reading it, I was also reminded of a recent debate in India where resources within the sovereign boundary of the country are conceptualized by the Supreme Court as under the as something as a public trust, where the property rights, the whole idea of the property rights, even when it is leased out to a private entity, it has to serve the interest of the country. This whole idea of public trust. So I was just trying to understand at that time that when the rivers also get the rights, the same rivers are treated as a legal person. Who would uphold those rights? Whether it's the court, whether it's the tribunals, whether it's the community, who will uphold those rights, and what are those rights? How can we understand those rights? Whether it will go beyond the public trust concept which has been so well articulated by our Supreme Court. But indeed it is a very, very fascinating, as my colleague just said, it is the theme of the future. The better we understand it at the very beginning of when the discourse has started building, and hopefully this workshop will contribute towards that. I again thank you, Mr. Justice, for taking out your precious time and being here, and I wish all the best to the participants and the delegates. Thank you so much.
A very short announcement and a request to Prashant sir. The announcement is it was supposed to be a round table, but keeping in mind the increasing COVID cases, we thought it's better not to have the round table and have a spread layout. So inconvenience is regretted. And now I would request our President, Mr. Prashant Kumar, to kindly give the bouquet to Honorable Mr. Justice Goel. I was supposed to give the introductory remarks. In fact, the introductory remarks that I proposed or thought of giving is actually the entire theme that comes as a flash in my mind, because I think the discourse began very recently. So it's still in that theoretical realm. It's a flash of theory that's coming to our mind. We are exploring, we are understanding the jurisprudential concepts involved in it. Because when the Uttarakhand judgment came, frankly speaking, as a lawyer practicing in India, the idea of legal rights for a natural resource, we never thought of. We thought of as something that we need to preserve, it belongs to all of us. In fact, the social scientists present in this room also thought of rivers, mountains, and any other natural resource in that way. In fact, the Niyamgiri judgment also told us that, okay, you all can participate, decide, because this is something that natural resource belongs to all of you. But when the Uttarakhand judgment came in, it gave us an opportunity to think and analyze the jurisprudential basis of that, whether or not the judgment deals with it. The matter is currently pending before the Honorable Supreme Court. There are at least 9 special petitions filed by all kind of persons, be it the Union of India, be it the states, be it the mining companies. So it's a batch of matter, a varied kind, and their concerns are absolutely different. In fact, the very batch of matter, the cause title would indicate the concerns that might emerge in future when we deal with the right-based approach to a natural resource. So therefore, I can only say that this is just the beginning of a jurisprudential journey, which I began about 1.5 2 years ago, when I started interacting with Professor Nayak on the legal rights of water, which some of our friends from abroad who are present, they had already worked on it, because New Zealand had a law, and even in other places there were judgments that we could read and understand while talking to each other. So I thought it's a golden opportunity for BI to take the lead in understanding and defining the idea of legal rights for natural resources, particularly water. Now I would request our President, Mr. Prashant Kumar, to kindly deliver his address. Of course, he needs no introduction. He is the President of Bar Association of India. He has been the past President of Law Asia, and he has contributed immensely on various aspects of law and economics, particularly even in river jurisprudence. I think he was part of the Ganga rejuvenation project as well, and he had given consultancies on that. So I would now request our President, Prashant Kumarji, to kindly deliver his address.
Thank you, Anindita. Honorable Justice Adarsh Goel, my esteemed colleagues, both from the Bar Association of India and TIS. Shyam is there, who has been a very well-known environmental lawyer to begin with, now a constitutional expert, has expanded his practice after coming here from Bombay. Mr. Katarki has been part of the river disputes due to Kaveri and Krishna tribunals from the time these disputes are there, so he is one of the foremost experts. We have Mr. Datta, we have our other colleagues who have practiced in various river disputes and water disputes, including Punjab, Satluj, Haryana, and my young friend Ranveer is there, who had been assisting earlier, Mr. Anil Divan, and now continuing providing the assistance, and there are several other young colleagues. So first of all, this is an interesting as well as intriguing jurisprudential concept. Interesting, yes, imparting a juridical persona to a natural resource or a body like river. It appeared to be quite a groundbreaking thing when it happened in 2017 in New Zealand. But if we go beyond the Western civilization, then what we see is that it is Christianity which, when moved from the pagan religions and pagan religions are nature worshippers. So where always the sun, the river, the moon, all were objects of worship and the religious iconography. So when Christianity came, this dichotomy between human or separation between human and natural or nature was embedded in the Western scholarship. But in other cultures, it always remains so. In India, the rivers are worshipped as deities, as Devis, and Brahmaputra is a Devata. So they are both male and female conceptualizations around river. And once you say a Devi, Devta, or a deity, so near Harsil there is a temple of river Ganga near the origin in Uttarakhand, and in that temple the deity is Ganga. So deity being Ganga, it is a juridical person as a deity. But now when in New Zealand in 2017, and I think my colleagues will be much better informed, I picked up this in 2018 August, when I was attending Presidents of Law Associations of Asia Pacific Conference, and at that time the president of New Zealand Law Society was Tiana Ipati, and her husband Matunuka Mahuika is a Maori. So over the dinner we discussed this whole thing, because by that time the Indian judgment had also come, and in New Zealand about the Whanganui River and Aotearoa, New Zealand, all going back to the treaty and that settlement, this whole conceptualization as a way out, more as a way out to how to balance the claim over the river basin, water usage of the Iwi and the Maori tribes, what you call, how to balance that. So as a way out, this conception was brought out that let us treat the river as a juridical person and give it a legal personality, and then construct a regulation. So like here also deity, the Pujari is the one who is kind of guardian, or the one. So they are also bringing the modern concept and the IV this thing, because the river flows right from there, and there are various rites, traditional and also modern. So the regulation is put up with joint Maori and other this thing, and all this conceptualization has been done. Now the same has been followed up in Colombia and in other places, because it led to a lot of excitement how to go about it. But as Anindita has pointed out, that when you confer any like a corporation or anything, a juridical personality, or impart a person, bestow a personhood, then the next question comes that it is not just the rights, it is also the obligations. So when you can sue, you can also be sued. So how all these things are going to pan out in the long run in different legal cultures, in different legal traditions. Another interesting thing, while working with Law Asia and BRICS, we work in both. Bar Association is a key participant in both. And there, in South Africa, there was, after apartheid, the whole thing, the Truth and Reconciliation Commission worked very well in South Africa. And the same thing was attempted to be implemented in Sri Lanka. And Kumara Tunge, the former president, she was made the head of a commission to see whether the same Truth and Reconciliation Commission can be brought in to function in Sri Lanka instead of the whole UN process of trying war criminals. Instead of that, why not heal the society? Why not bring them together? So I was part of a few discussions there, and the problem was that in South Africa, because of the legal tradition and the tribal ethos and values, this was part of their tribal value system. So a Truth and a Reconciliation Commission, where you come, you admit what you have done, and once you have done this, all what is there is bygone. There is a kind of a pardon, there is a kind of a reconciliation, was part of the cultural, historical and tribal iconography of South Africa. That was not the same in the Buddhist, Tamil, Hindu landscape, cultural landscape or historical landscape of Sri Lanka. So that's why that model could not be implemented in Sri Lanka because of these limitations. So that is why this concept is very exciting. It presents various possibilities where the rivers are treated as imparted a personhood. They are treated as religious entities. They are worshipped, but at the same time, sometimes the way rivers are worshipped or the rituals are carried out themselves provide an overload on the river system in terms of pollution, like when millions take bath in river Ganga, the whole lot of issues right from the water flow and how the things are to be managed come in. So it has its upsides, it has its downsides. How these are to be integrated with each legal system, each legal tradition is the real challenge. But I'm very happy that today we are beginning this conversation here. We are beginning this conversation from the environmental point of view, from the social point of view, and also from the legal point of view. And I think all these points of view must merge together, must cohere together to bring out the ultimate viewpoint around which this concept can be further refined and see how it can be utilized for the rivers being healthy, rivers having a eternal perennial flow, enriching civilization, enriching societies, enriching livelihoods around that, and of course water, which is one of the major sources of life. Thank you very much. Thank you, Anindita. Thank you, Tis, for giving this opportunity to the Bar Association. Thank you.
Thank you, Prashant sir. The next speaker is Mr. R. Venkatramani. He so much wanted to be here with us. He was traveling, he could not reach Delhi on time. However, that did not deter him from not thinking about us. He has been always very kind to BAI, and this topic especially is very close to his heart. He is also appearing for few states in many river disputes. In fact, he sent a poem to me on WhatsApp. He typed it in his phone and he said, Anindita, is it possible for you to read out my poem on river? So I would be, with the permission of everyone, reading that out. I have not written it. This is Mr. Venkatramani's poem. And he has also been very kind enough to actually send me a 8-point note that he wanted me to share with all of you. These are his views on legal rights of river. So first the poem, to make it little light. So rivers do not flow back. That's the title of the poem. Those unseen wombs of rivers' birth, up in the crevice of mountains steep, free from human grabs and camps, in joyous jump and fervent leaps, rivers do flow with songs and murmurs, as if in forward freedom grasps, ever and ever, with halting none, through woods and valleys of beauties great, in dialogues sweet but always deep, too deep for human minds for a peep. Down below, on soils flat, of colors and scents in blends allot, caressing Mother Earth with playful hugs, rivers do flow in eternal quest. Destinations for their journeys long are scripted sure in nature's logs, to seek their ends into oceans huge and seas so vast life ships do cross, appetites with measures none. Oceans and seas are the ends in whose silent embrace rivers know the truth of not ever going back, the truth of living journeys done, and the truth of the final resting home. I think a big round of applause to him. I got the opportunity to read a beautiful poem on his behalf, and we must not forget that he was also part of the Law Commission. So he wrote me that I'm hastily and hurriedly writing it, but he has actually titled an act of future enactment that he thinks should be there, and he calls it the Rivers Preservation Obligation and Responsibilities Act. And he says, he defines the purpose and goal of that act. All rivers are the life-giving, life-sustaining commonwealth of all people. Being the gift of nature which cannot be created by human efforts or will, rivers are planetary commons. All people have common and equal obligation towards their preservation and towards their existence and well-being. The well-being of rivers connotes their pristine natural state from origin to flow into the sea. Point number 2, there exists considerable legal instrument in respect of obligation towards river beds, such as sand digging, water tanks, canals, water courses and oceans and high seas, both in international law and domestic law. The enforcement of these obligations are also well laid out. However, owing to various deleterious human intervention into river systems, considerable and irreversible damages of river systems are happening. There is a definite need to reverse and arrest this uncontrolled and unregulated human intervention. The existing legal instrument, if any, are ineffective, soft, and their breaches easily condoned. A law to deal with various human interventions and their impact on river and their system is desirable. This law can provide for both preventive and regulatory obligation and can build on the current principles of ecology and environmental law. This law will enact river preservation principles, schemes, obligations and responsibilities, both of civil society and the government. This law will look at community participation and community involvement in enforcement, and more importantly, will be an aid to build and foster visions and attitude of various sections of community from school to home towards rivers and their system. And his last point was, this law can depart from current adversarial method models of law in regard to combination of enforcement methods. These are his views, and therefore he proposes the River Preservation Obligation and Responsibilities Act. Moving on to the next speaker, we have somebody who is so closely associated with any river dispute in this country. And I think, no guess, it's Senior Advocate Mohan Katarki. I think every river dispute in recent times that we can recollect as lawyers or otherwise as citizens of this country, be it Kaveri, be the Punjab dispute, be the current Odisha dispute, he is there always. He is the expert on water laws in this country. He has also taught as distinguished faculty in various colleges. He is also our vice president. He serves in various academic institutions and has written a number of papers and has contributed to various books on water law specifically. Just to put it in the perspective, he has represented, it's mentioned here, so I must read it out. He has represented states of Karnataka, Odisha, Punjab, Kerala and NCT of Delhi in several water disputes, both in Supreme Court as well as before various water dispute tribunals. So now I welcome Mr. Mohan Katarki to kindly deliver his lecture.
At the outset, may I thank the TIS and Bar Association of India for requesting me to speak on this occasion. Mr. Justice Goel, Professor Aseem Prakash and Shri Prashant Kumar, colleagues and friends. The topic for today's discussion is so exciting that I couldn't say no when Anindita spoke to me. Let me confess, until Uttarakhand High Court wrote the judgment declaring river as a legal person, which just happened after what happened in New Zealand, where this legislature passed the law declaring a river as a legal person, frankly, nobody had thought about it. I had attended a lot of conferences in India and abroad. Not once I heard any discussion on this topic, because somehow it was considered, for some reason, not important. But now I find everywhere a discussion on this topic. People are wanting to understand, people wanting to have something on what is this concept of legal person or personhood attached to the river or any of the environmental matters. The concept, actually, if you go back, it started in 1970s when Justice Douglas of US Supreme Court, in one of his dissenting opinion, hinted that it is not just enough to have the state responsibility put to protect the environment, which includes river, air, everything. It is necessary that we treat them as an independent person so that they have a standing locus to assert their rights. But it was too early at that time in early 70s to speak anything like this, because still we are to grapple ourselves with the importance of environment. Then Professor Stone, Christopher Stone, wrote an article, very beautiful article, which was published in the Southern California Law Journal, similarly advocating the status of a legal person to the river. Later, in 2008, the change came when two countries, Ecuador and Bolivia, declared the river as a legal person by constitutional provision. So it was something nobody expected to happen. It happened. And thereafter, New Zealand declared one of its park as the legal person. Subsequently, the river was declared as a legal person, and in the same breath, two constitutional courts, one in Colombia and one in India, declared the river as a legal person. So we have got two sources. Some of the countries by a legislative act have declared river as a legal person, and in some places the judicial pronouncement has conferred the status of a legal person. So with this, the consciousness has arisen. The environmentalists, the stakeholders have been repeatedly asking the question, why can't you declare all the rivers in India as a legal person? Well, it sounds very nice, we can declare that, there is no difficulty. But we'll have to little understand what is that we get and what is that necessary, where, to what extent a legal person should have the rights. To define, to confer a legal status is not a big problem. Any legislature can pass a law and confer the status. But the next question is, what are the rights which you are going to invest in that legal person so that he fights himself as a person to assert those rights. If you go back to the our constitutional provisions, the constitution is quite flexible in its framework with regard to the rivers. The state subject, that is entry 17, is the one which primarily governs any regulation on the rivers and river water. But it is subject to entry 56, which permits Parliament by declaration to take over the river, in a sense to regulate and develop if it is necessary in the public interest. Right, a declaration is necessary. So if Parliament wants, it can certainly declare and take over the regulation and development of the river. Otherwise, the river water lies with the state, even with respect to the interstate rivers. If there is any dispute with regard to the interstate rivers, then the parties have to go to the tribunal to break their heads. The tribunal will resolve it on application of the principles of equitable apportionment and define their shares, and that becomes the share or the pound of flesh of a state to be utilized by it as it deems fit in its best interest. That's how the constitutional provision is. Then if this is the thing, then how do you fit in this concept of a legal person? The legal person, the big problem is, as I see, under the Indian Constitution, entry 42 and 43 of the Union list do provide for incorporation of the artificial persons with respect to various, but it doesn't provide for the river. Similarly, the entry in the state list also does not provide. So the only recourse now is entry 98 of the Union list, that is a residuary entry, where the Parliament can declare the rivers as a legal person, which may extend to both interstate and intrastate rivers. So that is the position how the at the moment in India. If the Parliament desires and if it feels that it is necessary, it can certainly pass a law to declare all the rivers as legal persons, which includes both state and intrastate as well as interstate rivers. Then question comes, what is the necessity of declaring, and to what extent the powers, to what extent the rights should be invested in the legal person. As you all know, at present, everywhere, not only in India, it is the responsibility of the state to develop and protect the river. And in discharge of its responsibilities, the state has created various regulatory bodies, and in India we have the Greens Tribunal headed by a former judge of the Supreme Court to look into the grievances of the persons or stakeholders with regard to the environmental aspects, with regard to the aspects which go to protect the river. So these kind of regulatory authorities with regard to the protection of the river. Equally, the state has the agencies which look after the development of the water. That is, in fact, left to the states, state governments under our federal constitution, where the states take the responsibility of developing the water. And as I said, if there are any differences, then matter goes to tribunal for resolution, and thereafter the shares are allocated. So the responsibility of both development and protection of the river, the state discharges in this process in India. Now, if you declare a river as a legal person, you give a standing to that river. So by giving a standing, are you creating one more person in the game of dispute that goes on in the river water disputes? We see lot of persons are there, states fight, but individuals are not so far permitted to intervene. It is the position in one of the United States of America also. Individuals are not permitted. Here also not permitted. Now, if you create a person, that is a river, a person. For instance, you create Mahanadi as a person. Presently, the tribunal has been adjudicating the dispute. So, the Mahanadi river as a person has to be present in the tribunal to assist the tribunal with regard to the disputes between the two states. And what is that it can assist with the question. If you give a larger power to the authority or the legal person to look into the development of the water, that's very difficult, because then becomes almost a law unto itself that it will start deciding on the distribution of the water. I don't think that's permissible or possible also in the present context, because the states are so assertive of their rights. They are not going to accept any third person to decide with regard to the development of the water resources. In fact, way back in 1956, Parliament thought of such a body and enacted River Boards Act, thinking that there should be an integrated development of the water resources in the country. But unfortunately, the government of India did not constitute even one river board. So the entire River Boards Act remains a dead letter of law, because no state wants to agree for the constitution of the river board, which would have provided for integrated development. The only river board which was constituted in India was Damodar Valley Corporation, which happened in 1948 on the model of Tennessee Valley, which Jawaharlal Nehru and Ambedkar thought that's the best way to develop, but that didn't progress. The same model, it was tried to be enacted through the River Boards Act, it didn't work out. So that's how the situation. But nevertheless, there is a scope, there is a place, there is a subject matter with regard to which the river should be given their own status to assert. And what is that? Today we see, when take an example of any river, the developers are there. I call them developers, whether it is an intrastate river or interstate rivers. In interstate river, state is the developer. In case of intrastate river, the various the departments are the developers in the state. The developers usually look for developing the water resources till the last drop. When a dam is planned, usually it is planned at a 75% dependability or sometime even more. But it is planned in such a way nowadays till the last drop is extracted. In that case, the rivers which are perennial rivers, well, no problem. But in case of rivers which depend on monsoon, like Kaveri, Krishna, or any river other than the Himalayan rivers, what you see in the river, very sad thing, that it is all a dry bed, it is all a parched land. It's a pathetic scene to see that. This all happens because we have constructed so many dams, and dams have dammed the water. Behind the dam there is a plenty of water, but after the dam there is not a drop of water. So this water that is supposed to be in the river is called minimum flows or ecological flows. The concept started as a concept against the right to development. We all know there are two competing rights: right to develop and right to protect the environment. Justice Veeramantri, while writing his opinion in the famous Gapsico case, International Court of Justice, said the reconciliation of these two rights gives rise to a right to sustainable development. So if sustainable development is the concept, the minimum flows, ecological flows or environmental flows, whatever you call it, have to be maintained in the river. But who decides it? At the moment, there is nobody to decide. In a sense, nobody to assert for the river. What happens is, usually when the rivers are being apportioned by an agreement or by the judicial verdict, the tribunals have started keeping some portion of the water for environmental flows. It started again with the Krishna Tribunal headed by Justice Brijesh Kumar in 2010. Until then, in fact, there was nothing as such. Therefore, it is necessary to understand what is this ecological flows, and to the extent of asserting the ecological flows or environmental flows, if a legal personality is created and the river is permitted to assert its right independently before the interstate tribunal or before the state governments, wherever it is an intrastate river, I think the purpose will be met and there will be a lot of water to be seen during the non-monsoon months, which will relieve the river from the present parched condition, and that will help the flora and fauna. I am sure if the discussions which we are having today builds up a movement, it will really help a lot in expecting the Parliament to enact finally a law to create a legal person in the river to the extent of protecting the river from the undue developments which usually the state governments or the central sometime takes up with these things. I again thank the Bar Association of India and the Tata Institute for inviting me to speak here. Thank you.
Thank you, sir. In fact, while you were speaking about the juridical personalities, I had one of the judgments of the order rather of the Uttarakhand High Court, and in fact the problems that you are now indicating might arise because in fact in this particular order which is pending before Supreme Court, so without getting into the details of it, in fact who would represent the state in all legal proceeding has also been defined, and who all will be members and act as persons in loco parentis capacity and be the human face to protect, conserve and preserve river Ganga and Yamuna and their tributaries is also given in that order. So the problems and the issues that you are talking about shall surely emerge and we must start thinking about it.